aids many victims of sexual violence and provides an additional avenue.
Good afternoon and welcome to the fifth webinar of the Digital Dialogue Series on the progress and challenges of national efforts to address impunity for sexual violence in conflict. I'm Chloé Marnet-Bassanger and I'm the team leader for the UN team of experts. Today, our discussion will focus on the justice response to conflict-related sexual violence crimes associated with slavery and trafficking. While sexual slavery has been an integral part of the definition of conflict-related sexual violence, it was not until 2016 that the Secretary General and then the Security Council, through adoption of Resolution 2331 and 2388, broadened this definition to include trafficking. This inclusion was prompted in part by the alarming trends witnessed in Iraq, Syria, and Nigeria, where the trade and sales of women and girls for sexual exploitation was an inherent feature of the modus operandi of terrorist groups like Daesh and Boko Haram. Yet, despite this political recognition, the Council's normative endeavor was not accompanied by greater judicial response for these crimes, and justice remains elusive. Investigation and prosecution for conflict-related sexual violence crimes associated with slavery and trafficking at the national, transnational, or international level are practically non-existent. We have with us 6 leading practitioners and experts whose daily work seek to address this exact challenge: how to improve the justice response offered to victims of conflict-related sexual violence crimes associated with slavery and trafficking. And to guide this dialogue, I'm truly delighted to introduce you a longtime friend of the UN team of experts, Professor Patricia Sellers. Patricia's contribution to the field of international criminal law, humanitarian and women's rights is widely known. Between 1994 and 2007, Patricia served as the legal advisor for gender, the acting head of the legal advisory section, and a prosecutor at the UN International Tribunal for the former Yugoslavia. She was responsible for the development of unique legal strategy, which led to pioneering judicial decision and set the standards for the interpretation of sexual violence as war crimes, crimes against humanity, genocide, torture, and enslavement. She has lectured and written extensively on humanitarian law and international criminal law. Patricia currently teaches at Oxford University and is the special advisor for gender for the Office of the Prosecutors of the ICC. Patricia, over to you.
Thank you very much, Chloe. And thank you very much for the invitation from the team of experts and from the other organizers of the Digital Dialogue series. I want to jump right in because our time is limited. And while it seems as if an hour and a half gives us ages in which to discuss, you'll find out that each of our presenters are very, not only specialists, but also gifted presenters and how they will bring forward the issues that are so very important. It is actually the first time that there has ever been a conference that I know of that is juxtaposing both issues of sexual slavery, the slave trade, and trafficking. So I would like to start by giving the floor to our first panelist, Amina Hassan. Amina is a Yazidi human rights activist. Between 2010 and 2014, Amina served as a member of the Iraqi parliament. but in her last years of work, she focused mainly on advocacy and promotion of the rights of Yazidis. She has been awarded a number of prizes in recognition of her extraordinary work, including United States Department Hero Acting to End Modern Slavery, and in 2015, the Human Rights First Annual Award. Amina, it's a pleasure to have us with you. In 2014, thousands of Yazidis were kidnapped and enslaved by the terrorist group ISIL. At that time, the local government sponsored a team of local activists who worked on freeing captives. Amina, you were part of that team, and since then you have worked tirelessly to find and free many of these individuals. You heard on many occasions firsthand about what happened to the girls and the women, and I would also add the boys. So my first question to you is, can you tell us about some of the stories of the girls and of the boys and of the women that you've rescued? And can you tell us what, in your opinion, could bring them some sense of justice?
Thank you so much, Patricia, and thank you so much for the other panelists and for the audience. Thank you so much for the opportunity to focus again on what happened to the Yazidi minority from the 3rd of August 2014, when the terrorist group ISIS attacked Sinjar district. Sinjar located in the north of Iraq. During this attack, ISIS killed thousands of Yazidi men, murdered older women, who according to their beliefs would not bring any benefit to the ISIS. And they abduct more than 6,000 women and children. I'm here today because as a Yazidi activist, I have worked with many of the kidnapped victims and their families. First, to identify those who have been captured, then to try to release them. Today, I want to share with you the scope of the abuses and human rights violations committed against my people. As soon as they were captured, the women and girls were transported via trucks to various locations between Iraq and Syria, as if this human beings were a flock of sheep. When they arrived to their destinations, these people insulted, tortured, and one who were older than 9 were raped and sent to slave markets. Indeed, after separating the mothers from their children, each girl received a number that they had to use instead of their names. The women were dressed in fashionable clothes, forced to wear makeup before being displayed as if they were objects in front of ISIS fighters. The leaders of ISIS were the first ones to choose among the women and girls. The fighters were only allowed to buy women and girls after the leaders. Fighters then didn't hesitate to wrestle a woman they had grown tired of. I have heard testimonies of women who have been sold more than 10 times. If any woman or girl refused to be sold or showed any sort of opposition, she would then be punished and tortured harshly. These women and girls were bought like merchandise to serve various purposes, including to perform housework and serve the wives of the fighters and the leaders. They also were used as sexual slaves. I have many stories in my mind that I cannot forget. The first time we received a call from a girl captured, she was with her sister and another girl in the Iraq area in Mosul. She told us how they could not handle the trouble situation any longer and that they were thinking of committing suicide if they were not freed. Me and other activists, we thinking, how can we help? It was extremely challenging, but thanks to the information we collected, the close coordination we established with the other activists and the families of the victims, we were able to free them and reunite them to their families. To be able to recover from the many traumas they suffered, these victims all need such psychological support, have a safe income, and to be safely reintegrated into their communities. Many still live in camps with other displaced population under very harsh living conditions. However, despite all challenges they face, many of the victims I spoke to are asking for justice. Even though they have lost trust in anyone, they hope that the terrorists who enslaved them, traded them, and raped them will be held accountable in front of an impartial and independent national court. But today, Iraq faces divisions, political challenges, economic issues, and corruption, which raises concern regarding the capacity of the national courts to prosecute these cases. Also, due to the lack of technical capacity, some evidence is disappearing, as is the case for some mass graves. Many victims and witnesses are fleeing Iraq, including because they fear for their safety. Also, many terrorists have escaped to foreign countries, some in Europe and many in Turkey. In my opinion, and according to the testimonies of the victims I have heard, achieving justice will mean to punish those responsible of these heinous crimes regardless of where they are in any country of the world. But it is important not to waste any more time, as these crimes have already started being committed 6 years ago. We also hope that the survivors will be treated fairly. Today, they live in camps where they miss the most basic necessities of life. They need to be treated with dignity and receive compensation for the harm they suffered. Only then the human dignity of the victims and their families will be restored. Thank you, Patricia.
Amina, thank you very much for that insightful recounting of the complexity, not only of transport, slave trading, but also the question that justice is going to be difficult in certain countries, and that in the meantime, the economic situation and the actual livelihood of the women and the girls continues to be a struggle. Thank you. Our next guest is also familiar with many of these stories. Stephanie Babar has worked extensively in documenting and investigating these crimes. She's an international criminal investigator, analyst, and legal advisor with over 14 years of experience in domestic, hybrid, and international criminal justice initiatives. Her work is focused on Rwanda, the Balkans, Nepal, Syria, Iraq, and the Central African Republic. Since 2015, Stephanie has served as a senior advisor on the sexual and gender-based violence at the Commission for International Justice and Accountability, CIJA, where she conducts evidence collections, analysis, and case building on crimes committed in the Syrian regime and by the Islamic State, particularly those crimes that relate to sexual and gender-based crimes. Stephanie, CIJA was specifically established to conduct private investigations of international criminal and humanitarian violations in Syria. Your article in the special issue of the Journal of International Criminal Justice, which is a wonderful article, specifically talks about how CIJA's team adopted an investigative model that focused on identifying trends and patterns in large geographical and temporal parameters. This model allowed CISA to document in detail the slave trade system that was implemented by ISIL. So the question I would like to pose to you now is, can you tell us more about the challenges of investigating this specific phenomenon and the strategies that you used to ensure that the collection of evidence would meet the needed evidentiary standards, irrespective of the jurisdiction that the evidence eventually was transferred to?
Thank you, Patty. It's a pleasure to be with you today and our hosts and my co-panelists. Well, that's quite an introduction and quite a question. I'll try to address all of it. I think many of those joining us in the audience today are very familiar with the many challenges in investigating the kinds of crimes which Amina has just so searingly accurately summarized in her remarks. Among those, of course, are the very difficult operating environment that we encounter in conflict and post-conflict situations, the trauma and vulnerability of the survivors and other witnesses. And in respect to Daesh or IS's crimes in the context of the slave trade, we have the fact that these are very much ongoing crimes. And it was a situation in which rescue operations were running concurrently with investigations and obviously have a higher degree of importance. There's also the issue of over-documentation of survivor accounts, which we could have an entire webinar about itself. And the final one I'll mention to shape my remarks is the inability of, in some cases, the territorial state and in some cases, third states to gather evidence and build strong cases. And it's really that last one that led to the creation of our NGO, the Commission for International Justice and Accountability, CIJA, and the creation of this model of private criminal investigations driven with national investigators on the ground. Before I come to some of the strategies we've used to address those challenges, I think I should first acknowledge that we didn't necessarily know which legal framework, as you referred to, Patty, would apply to cases that we built. So our approach has always been to try to meet or exceed the standards established by international and hybrid criminal tribunals around the world over the past number of years. And concretely, that means several things, a few of which I'll mention. Adhering to very ethical and principled approaches, of course, in dealing with survivors. And in that respect, our national investigators, who are Syrians and Iraqis, including Kurds and Yazidis, have invested a great deal of time in training and being mentored in order to be able to guarantee that they can live up to those standards. Having robust policies, including, of course, on important issues such as investigating inculpatory as well as exculpatory evidence. And having rigorous procedures and oversight on things like informed consent for witness interviews and chain of custody over documentary or other types of evidence. That leads me to some of the strategies we have employed. As you mentioned, a key one is that we engage in large-scale situational investigative models, very much like the International Criminal Court or other tribunals. That can differ slightly from what other NGO documenters do, which might focus on gathering evidence about a single victim or a cluster of victims, which may be sufficient for bringing a strategic litigation complaint or filing an Article 15 communication to bring a situation to the attention of the ICC prosecutor. But in our investigation plans, investigations are defined in very broad subject matter, geographic and temporal scope. So in the case of what we're talking about today, IS crimes in northern Iraq and Syria from mid-2014 onward. And as you can see, we were not initially focused on enslavement. Instead, that was something that was allowed to emerge because of the broad scope of the investigation. Very closely linked to that is our focus on gathering and analysing evidence of the structures and authorities within the perpetrating organisations or institutions that enabled the commission of the crimes. We were able, using that approach, to build a legal brief about IS enslavement practices that demonstrates that there was a highly orchestrated, well-regulated slave trade that allowed for the buying, selling, trading, and giving of thousands of women and children across the IS-held territory in northern Iraq and Syria over a number of years. And what is more, that it used many parts of its state-like apparatus to facilitate the perpetration of those crimes. I think many onlookers are aware of the slave markets, but for example, the Sharia courts run by Islamic State were also deeply involved in doing things like presiding over the transfer of ownership of human beings, or even enacting marriage contracts between slaves and IS members, which gave a veneer of marriage to something that was still very much a condition of slavery. Moving on, just mention briefly our evidence collection strategy that allowed us to come out with such strong findings. Our approach was to gather multiple layers of corroborating evidence. And in the article, I talk about this as the pyramid approach, which may not be a perfect metaphor, but serves to clarify what I mean a little bit. At the top of the pyramid, we have the survivor's testimony, and it's at the top because it's extremely valuable, not only as crime-based evidence, but often we have found, because women and girls were held with high-level members of IS in many cases, that it's very valuable linkage evidence too. It's also at the top because it should be the least amount of evidence, or at least it should in a private investigation where later on a prosecutor might reinvestigate and want to speak with more witnesses when justice is more imminent. And underpinning that first layer in the middle is documentary evidence, hopefully, if it's available. And in this case, it was two important categories exist: the IS documents that set out its policies that permitted and justified slavery, and also the day-to-day documents that illustrate its functioning in practice, such as the marriage contracts I mentioned. And finally, the base layer, the broadest layer, which should show the scale of the crimes, because after all, at the top of the pyramid, we're only looking at a few survivors out of the many, would be pattern evidence, including expert forms of evidence that can help show the widespread and systematic nature of the crimes. Gathering those multiple forms of evidence is important, not just for avoiding over-reliance on survivor testimony, but also for allowing the contextualization of the crimes. And that's a term I borrow from a wonderful book that came out of ICTY practice, allowing us to show linkage of the underlying acts to the wider context, such as the attack on civilians, but also importantly to high-level perpetrators, so that cases can be built against leadership. I see I got my 2-minute warning, but I think I have time to make my final point. I'm getting a nod. Okay. I'll just briefly mention our practice of preparing our evidence in the form of legal briefs. Our legal brief on IS enslavement practices sets out all of our factual and legal analysis and is over 450 pages in length. In the briefs, we are able to explore multiple legal characterizations for the crimes. And insofar as the brief deals with enslavement of Yazidis, we did find that this amounts to genocide. And we also explored characterizations as crimes against humanity and war crimes, including in respect of non-Yazidi victims. We also explored categorizations under customary international law and domestic law. So two I'll mention before closing is the crime of slave trading in women and children, which exists in customary and treaty law, of course, but is also found in the Iraqi Penal Code and could be used as a characterization for these crimes. And we also argued that the fact pattern in this case may fit the definition of trafficking, also found in the domestic law of Iraq. The purpose of these legal briefs is really to help show what kind of evidence is available and what kind of legal characterizations may be possible. And we make them available to our law enforcement partners so that they're able to send us requests for assistance or eventually, hopefully, even requests for evidence in proceedings. And this is an area I think we'll come back to in the Q&A as one of the imminent prospects for at least a small amount of justice for these crimes, which we will hopefully be able to contribute these findings to. Thank you.
Thank you very much, Stephanie. You've taken us to a reiteration of the facts that Mina brought out, but as you're looking at them from an investigative point of view, to your investigative strategies, and then finally to your procedures. So very thankful for that presentation. Our next speaker is also very much engaged in these issues that have been raised of the slave trade. The panelist is Jocelyn Getjen. Jocelyn is an associate professor of clinical law at Cardozo Law School in New York, where she is also the director of the Benjamin Friends Human Rights and Atrocity Prevention Clinic, as well as the director of the Cardozo Law Institute on Holocaust and Human Rights. In the last years, Jocelyn wrote a number of award-winning articles and conducted original in-country research in several countries throughout Latin America, Africa, and Asia. Her commitment to international human rights has won her Cornell's Freedom Award for Civil and Human Rights. In the public sphere, these heinous acts that Amina and Stephanie described have been heavily condemned as unacceptable, as crimes of trafficking or as crimes of sexual slavery. However, in the article that we co-authored, Jocelyn, for the special issue of the Journal of International Criminal Justice, we've reflected on how these offenses, trafficking and sexual slavery, as currently defined in the Rome Statute, do not encompass the full extent of criminal acts perpetrated in the context of the slave trade system. So my question to you is, can you tell us how existing international criminal law and jurisprudence may be ill-equipped to ensure the prosecution of these crimes, and whether these shortcomings could be effectively addressed?
Thank you, Patty, and thank you to all of the hosts and to the UN team of experts for convening this fantastic panel of speakers today. So the short answer to your question is that existing international criminal law does include an additional crime that is missing in action, so to speak, from the most recent codifications of international criminal law. And I'm speaking mainly of the Rome Statute of the ICC, but also from recent international criminal law jurisprudence. And that international crime is the crime of the slave trade. The slave trade prohibition is one of the first recognized and yet least prosecuted crimes. It's codified in, among many treaties, the 1926 Slavery Convention, the 1956 Supplementary Slavery Convention, and it's found in Additional Protocol 2 to the Geneva Conventions. And the slave trade enjoys the highest status in international law. It's a jus cogens norm, which means it's peremptory, and which means that there is never a justification for perpetrating the slave trade. And with that jus cogens status comes attendant erga omnes obligations, which means they're owed by everyone to all, and So if they are breached, any state may claim injury for slave trade crimes. The slave trade is also a crime, as Stephanie was mentioning, under customary international law and is a prohibition under international humanitarian law. It also is a non-derogable human right, which means even in times of public emergency, national security, there's never a reason for ever engaging in the trade in human beings. The slave trade is first defined in the 1926 Slavery Convention, and then it was slightly revised and expanded upon in the 1956 Supplementary Slavery Convention, but I'll read the definition from the 26th Convention as it is pretty much how the definition stands. It's all acts involved in the capture, acquisition, or disposal of a person with intent to reduce him or her to slavery. All acts involved in the acquisition of a slave with a view to selling or exchanging him or her. All acts of disposal by sale or exchange of a slave acquired with a view to being sold or exchanged. And in general, every act of trade or transport in slaves. So the slave trade condemns perpetrators who acquire and intend to reduce all persons, males or females, adults or children, into slavery. Or, and this is important, just as important, who further the exchange or transport of a person already enslaved to another situation of slavery. And while slavery defines who is enslaved and who is a slave owner, the slave trade defines how one is reduced to slavery, how one is transported as an enslaved person and or maintained in slavery, and by whom. So while these crimes are occurring in tandem, they are, and this is what we want to really emphasize today, they are distinguishable crimes, and they're able, as Stephanie was talking about, to be pursued separately and concurrently. Slave trading usually precedes, it almost always precedes, acts of slavery, which is why we have referred in the article to these acts or conduct as precursory acts, precursory conduct to slavery. And as Amina was describing so eloquently at the beginning of the panel, the precursory conduct that international criminal law jurisprudence has often explained, and they're using the same terms, such as capturing, kidnapping, abducting, buying, gifting, transporting, holding, etc. Those acts could be characterized as acts of slave trading, but they haven't been legally characterized, at least in the international criminal law jurisprudence, as those courts have not been resorting to customary international law, and because the slave trade is missing from the Rome Statute. And these precursory acts could constitute the actus reus of the slave trade, the crime of the slave trade. The fact that the slave trade is missing from the Rome Statute, especially from the war crimes provision, but also from the crimes against humanity provision, is really an egregious omission. And that omission really has to be corrected moving forward. Patty and I have done some work calling for revisions of the Rome Statute, both in Article 7 and Article 8, to include the crime of the slave trade explicitly. The fact is that these laws that are prohibiting these crimes, slavery, the slave trade, and human trafficking, are complementary, especially when we're talking about conflict situations where there are several bodies of law operating concurrently, as Stephanie was describing. We have, including international criminal law, international humanitarian law, transnational criminal law, human rights law, and even the domestic criminal law is all operating in this conflict situation to potentially give jurisdiction for justice for the survivors. And slave trade brings something additional to the table. When we think about the survivor's perspective specifically, there are 2 or more crimes that have often occurred in these situations, these factual situations. A person is nearly always slave traded into slavery. So even if we're talking about the same perpetrator who's bringing an individual into slavery and then exercising ownership powers over that person, that same perpetrator has committed the crimes of slavery and the slave trade. And by ignoring the survivors' points of view, by overlooking the crime of the slave trade, that is increasing impunity. And it's increasing impunity, especially when we have more than one perpetrator engaging in these different acts. Sometimes we have perpetrators trading slaves while the other perpetrators are engaging in slavery, the crime. But those perpetrators, when we have separate perpetrators of the slave trade, are often being overlooked. And that criminal conduct could be characterized as an international crime. The other added value of the slave trade is that when we look at the elements of the crime, we look at the intent of the perpetrator to bring someone into slavery or maintain them in a situation of slavery. We don't need to consider the age or gender of the victim or any other characteristics. The subsequent exploitation, there's no requirement that a person is ever abused, exploited, or even enslaved. There are no circumstances of coercion that are required under the elements of the crime, no questions of consent. It's actually irrelevant in terms of slavery and slave trade crimes. And in fact, the slave trader does not ever need to exercise ownership powers over the individual. The international crimes in general also have no statute of limitations. And so that is also something that gives this crime a supernormative status. So as Patty and I have described in the article, we think it's time to send out the search party. We need to be utilizing the slave trade because the crime, as Stephanie and Amina both were describing, is being committed and it's being perpetrated against victims and survivors. And those victims and survivors need to be able to fully access the justice they deserve. Thanks, and I look forward to questions.
Thank you very much, Jocelyn. You've raised some very important points whose ideals I certainly share. But also you've raised the point of when we have a legal regime that is possible or potential, but yet not efficiently used, that we're actually adding to impunity. We're going to our next panelist now because Aimé Compris comes from a different legal approach to these horrendous facts that we've been listening to. And Aimé is the project coordinator of the United Nations Office of Drug and Crime, Global Action Against Trafficking in Persons and the Smuggling of Migrants. That's a mouthful, okay? GLOAC. She leads the implementation of a project that supports criminal justice responses to trafficking in Afghanistan, Bangladesh, Iran, Iraq, and Pakistan. From 2015 to 2018, Amy led the delivering of technical assistance to national partners in Latin America, Africa, Eastern Europe, and Asia. Amy is a qualified lawyer with 16 years of experience in supporting international investigations and prosecutions. And prior to joining the United Nations Office of Drugs and Crimes, Amy worked with the Office of the Prosecutor of the International Criminal Court. Wonderful. And later as a legal advisor to the OSCE, Special Representative in Combating Trafficking in Human Beings. United Nations Office of Drug and Crime has worked with several member states to strengthen the criminal justice response, specifically to the crime of trafficking, including in Iraq, where some of the worst crimes that we've heard described today occurred. Amina and Stephanie, back to your presentation. Very insightful. Yet we know that the prosecution of trafficking by national courts is still lacking. So, May, my question to you is based on the United Nations Office of Drug and Crimes experience in Iraq in particular, but also more broadly, what are the main challenges, not only in the legal framework, but beyond in its implementation? What is it that is preempting the prosecutions of these crimes at the national level?
Thank you, Patty. And I would like to thank the organizers for this opportunity to contribute to this very interesting and timely discussion. And let me also congratulate the UN team of experts on their 10-year anniversary and an impressive body of work. The question of the role of the national courts in prosecuting trafficking persons is absolutely key towards closing the impunity gap for victims of sexual violence in conflict. While there has been growing recognition of trafficking persons as prevalent in conflict and post-conflict settings, and the highest level of commitment from governments to address it, from landmark Security Council resolutions to the mobilization of donors, governments, and civil society more broadly. It is well known, as described compellingly by Amina today, that armed groups such as ISIS have been committing sexual slavery, forced marriage, and other forms of sexual violence. What's often less discussed is the nexus between armed and terrorist groups and organized crime. So trafficking is a systemic component of conflict, not only for sexual exploitation, but also for forced labor, organ removal, and the conscription of children. Clearly, armed criminal and terrorist groups take advantage of the lack of rule of law to carry out the dirty business of trafficking in persons. The United Nations Office on Drugs and Crime, or UNODC, is the lead agency within the UN system addressing trafficking in persons, and the link to sexual violence in conflict has been at the forefront of our technical assistance for several years. It was the subject of a special issue paper in 2018, and again confirmed in our flagship Global Report on Trafficking in Persons, all of which outlined the necessity of integrating anti-trafficking work firmly within the conflict and post-conflict response, as well as the rule of law response. It is important to note that the UN Trafficking in Persons Protocol, which UNODC is the guardian of, has achieved one of the highest ratification rates in a relatively short period of time in the history of international law, with currently 178 member states who have ratified the protocol. And the vast majority of these have adopted national criminal legislation. This is a strong indicator of the international consensus on the protocol's definition and approach. So it would seem that there is unlocked potential here. Within domestic trafficking in persons legislation, we often see very comprehensive and forward-looking frameworks with a number of benefits for victims. The protocol's definition has three elements: act, means, and purpose of exploitation. And while the term trafficking evokes the image of border crossing, the protocol in fact does not require any movement at all. Indeed, evidence to date suggests that internal trafficking is on the rise. The protocol includes both hard and soft means of exploitation. So the force or abduction or threat of force, which was described by Amina and Stephanie today, such as seen with ISIS, but it also includes the softer means such as fraud, deception, and abuse of a position of vulnerability. We know that emotional abuse and humiliation of victims are two important psychological forms of control, which the courts are increasingly recognizing. And we also know that traffickers sometimes rely more on the subtle means of control over their victims, taking advantage of quote unquote willing victims in dire circumstances. Within the trafficking jurisprudence, there has been an evolution in the thinking around the concepts of ownership and slavery. While modern day slavery is an effective advocacy term, it can be misleading as it suggests total ownership, when in fact a victim of trafficking may have some freedom of movement and may not look or appear as you might expect. The protocol is very helpful because it includes clear language on consent. So consent is irrelevant or vitiated where the means are present. For children, the standard is even clearer. No child can ever consent to their own exploitation. The principle of the non-punishment of victims, including the non-prosecution of victims for crimes they were compelled to commit as part of their exploitation, is increasingly recognized as an important soft law principle essential to the protection of victims. I lead a team at UNODC, the Global Action to Address Trafficking in Persons and Migrant Smuggling, or GLOAC for short, and we work to support the governments of Afghanistan, Iran, Iraq, Pakistan, and Bangladesh, generously funded by the European Union and delivered in partnership with IOM. GLOAC aims to build a community of practice. In brief, we provide technical assistance to our partners. This means that we do not investigate or prosecute the crimes ourselves, but we work alongside with the governments. And we do this through mentorship of key law enforcement officials, prosecutors, and judges, empowering women leaders at the national and regional level through the Glow Act Women's Network, on the premise that increasing women's decision-making power will improve the overall response. We are supporting legal reform and the development of effective national policies. We're looking to identify specific routes and flows and relevant partners at the state and organizational level to support and bring together the seeds for joint investigations, looking to dismantle actual criminal networks through these. We are focusing on the illicit financial flows associated with trafficking through innovative new research being undertaken right now, looking, for example, at the role of the hawaladars and informal transfers, the profit of which we know is driving this crime. And we also are serving as a conduit for communication between civil society and victim advocates to the authorities, helping to have their voice heard and integrated into the national mechanisms. A closer examination of the key evidential challenges facing investigators and prosecutors, both within the trafficking regime and the atrocity crime regime, actually reveal a number of striking similarities. And I say this as someone who has worked in both of these frameworks. So access to the territory, ensuring victim and witness protection and safety is at the foremost of the challenges in ongoing or often, or also in the post-conflict area. Overcoming the lack of official identity documentation among displaced populations, securing international judicial cooperation, building a solid evidential base relying on open source expert evidence, financial and forensic, not only on witness testimony, identifying key informants or insiders whose testimony could be critical, and perhaps most crucially, as nicely laid out by Stephanie in the work of CIJA, investigators of each crime will struggle to link the underlying crime base, the individual crimes, with the higher level command of the organized armed group or leader. In conclusion, trafficking of persons, especially for sexual exploitation, is prevalent in conflict situations and yet has rarely been tackled as such. What is clear is that the effective investigation and prosecution of organized crime, including trafficking in persons, is a key strategy in promoting complementarity and ending the impunity gap for sexual violence and conflict. The two legal frameworks must be seen as mutually reinforcing. And the fact that there are so many shared evidential challenges is an indication of the potential for increased cooperation between UN agencies, member states, international organizations, justice mechanisms, and civil society. And while it is difficult to collect this evidence and mount effective investigations against higher level targets, it's not impossible, and we are regularly seeing breakthroughs. Indeed, UNODC's Global Report on Trafficking in Persons confirms that investigations and convictions are on the rise, and an important correlation. The more time has passed since a country has ratified the treaty, the more cases are being brought forward. So this tells us that this approach is working, but it takes an investment of time, resources, and capacity. We're delighted to count on the extremely strong support of the government of Iraq and the excellent collaboration so far. We continue to learn from our experiences in Iraq, but we are also learning from other countries where we've been supporting, including in Mali, Niger, Colombia, Nepal, and Kyrgyzstan, just to name a few. At UNODC, our focus is on improving the quality of the criminal justice response over the quantity of cases being brought forward, aiming to ensure that the cases going to court target decision makers and those profiting, and moreover are not doing any harm to victims in the process, neither by charging them, not recognizing their agency, and ensuring that their long-term protection and assistance needs are met. I can only stress the importance of national ownership. Sustaining national authorities directly can ultimately lead to a greater behavioral change and impact, and have a good chance of those being well received by the society and carried on. Thank you.
Amy, thank you very much for your presentation, and I would recommend your article in the volume to anyone who is in our audience today. You've really been able to give us the gist of many of the challenges that separate nations might face, but I was heartened to understand the high number of ratifications and the ability to really increase the quality of such investigations or prosecutions. So congratulations. We're going to turn to our next panelist, who will be our last panelist, our final panelist, is Mr. Val Ritchie of OSCE. He's a special representative and coordinator for combating trafficking in human beings. He represents the OSCE at the political level on anti-trafficking issues and assists 57 OSCE participating states in the development and implementation of anti-trafficking strategies and initiatives. Before joining OSCE, Val worked for 13 years as a prosecutor in Seattle, Washington, in the United States. He handled sexual assaults, child exploitation, and human trafficking cases. He led a coalition there of law enforcement, civil society organizations, academics, service providers, philanthropists, and policymakers focused on the eradication of commercial sexual exploitation and trafficking in Washington state. Prior to being appointed as the OSCE Special Representative and Coordinator for Combating Trafficking in Human Beings, Val, you were a prosecutor handling human trafficking cases. And since you took office, you've become known for your innovative and practical approach to the mandate. And in 2020, you promoted a series of initiatives to assist OSCE participating states in countering impunity of perpetrators. So my question to you, as a former prosecutor and a diplomat, how do you think that international policy can shape or contribute to improving national practice and local responses? Can you give us some specific examples as how a former prosecutor, you see actions taken by OSCE influences practice and empowers practitioners as well as victims?
Well, thanks, Patricia, and thanks also to the fantastic presentations by the panelists so far. It's really a privilege to be listening to these great experts outline some really fascinating arguments and conversations. You know, Patricia, as I was listening to your bio and about sexual violence in the ICTY, I was reminded that I served as a legal intern in the prosecutor's office of the ICTR in Arusha. And when I arrived there, this is early 2000s, the concept of rape as crime against humanity and eventually part of genocide was very new. And I worked on a case where one of the victims or one of the witnesses was a victim of rape. And it was sort of early days for them establishing evidence to support this. And it occurred to me that that's such a great example of how international policy can influence practice, because what happened is that as international policy developed, our whole perspective around sort of what constituted these crimes started to develop and change. And this was brought into really sort of specific relief for me a few months ago when a survivor of sex trafficking named Tamaya Nagy spoke at one of our events. And she said, and I want to look at it here so I don't mess it up, but she said, when it was done to me, what was done to me was not even a crime. She was trafficked, and when it was done to her, it was not a crime. And now, as Amy just so eloquently reviewed for us, the Palermo Protocol has managed to be ratified by over 170 countries, resulting in most of those countries having a crime in their national statutes that responds to trafficking in human beings. That is amazing. And I think it's an amazing example of how international norms can really change our sort of understanding of the world, our perspective of the world, including our notions of criminal justice, which often I think we think of as sort of immutable and persistent, but actually these policies, these international policies, can change our whole perspective about what constitutes a crime, so that there's a survivor like Tamaya can be horribly harmed at one point in her life in a way that doesn't even count as a crime, and now it does. And the result, of course, is that all these countries have trafficking statutes. And the trafficking statute in the Palermo Protocol is hugely helpful for all of the things that we've been talking about here today. And one reason that it's a great definition of trafficking, the first internationally agreed upon definition of trafficking, one reason that it's so great is that it encompasses all of the actors in the chain of exploitation. Amy just described the elements of it, but what it talks about is anybody who recruits, transports, transfers, harbors. This is anybody who comes into contact with a victim in the context of this trafficking chain can be held responsible for trafficking. And so from a prosecutor's perspective, what I see there, and this is, I haven't heard this discussed a lot, but I think it's hugely relevant in the context of trying to address an impunity gap. What I see there is a fantastic accomplice liability statute, where you are getting everybody who comes into any kind of contact with this potentially falls under the trafficking definition. That is a huge asset, because then you can get all of these folks who are touching this this crime in the countries that we've just been talking about, in conflict-related areas. You can get anybody and pull them under this statute and hold them accountable. I think that's fantastic. So my answer to your question is clearly international policy has an important role to play. What we also know is that where there's a lack of international policy, there's problems. And one example would be around technology right now. There's very little international agreement policy-wise on technology as it relates to trafficking, yet technology is being misused widely by traffickers to cause crimes. And instead what's happening is countries or regions, for example, this just happened in the EU, they got really hung up on the issue of child exploitation, online child exploitation versus privacy rights. And the discussion devolved into a binary choice between the two, and the result was that people who are being exploited online sort of lost out in some of the decisions. So what that means is that where you don't have international agreement, international norms, and I think a unified consensus policy, you start to run into problems about how that's going to be implemented. So what are the challenges right now? Like, why? I mean, I just talked about, we have this great convention. We have laws everywhere on trafficking. Why aren't we winning? Why is there an impunity gap? Well, one reason is that low prosecutions. People aren't using the law. They don't implement themselves, and they're not using it. And how badly are they not using it? Well, globally, we estimate, based on the data that's available, that only one trafficker is being prosecuted for every 2,200 victims. Now, I ask you, in what other scenario would we ever tolerate such horrendous injustice, such that you are telling 99% of victims, forget it, you're never going to see any justice at all? We would never do that if it came to burglary, car theft, rape even. But when it comes to trafficking in human beings, we have tolerated it at a huge level. And when it comes to conflict zones, I think it's much, much worse. It's probably 1 out of 4,000 or 5,000 victims or something. So I think what we need to do is really have a cold, hard look at the scale of the problem and how to move from a great law that you might have in your country to actually implementing. Second thing is failure to sort of, I would say, implement some of the provisions that really protect victims. And here I'm talking about non-punishment principle, which was brought up earlier. This is rarely used in the context of people who are victims of sexual violence, and instead they're often prosecuted because they're around a terrorist organization. And here you have conflict between terrorism-related law and trafficking-related law. So what are we going to do about this? I'm deeply concerned about the impunity gap, and I think that some steps need to be taken. First thing is training and capacity building, which a couple of the other speakers mentioned, I thought really well. We need a much more understanding of the scope and use and flexibility of the trafficking statute to hold people accountable in conflict areas where we might not otherwise be able to hold them accountable under other bodies of law. This requires flexibility on the part of prosecutors, but I think they can do it. Second of all, we need to listen to victims a little bit better. And I heard the word survivor several times today. I think incorporating survivors' perspectives about how to work with them properly and how to best engage with them to support them to meet their needs so that they can be productive witnesses, so that they can be saved, I think is really, really crucial. And finally, I think one of the crucial factors here that will move us from a great law into implementation is political will. A lot of these other things, training, capacity building, resources for survivors, those all flow from political will. And we can talk about great laws all day, but if the resource and investment and commitment isn't behind it, you're not going to see really fully implementing. final point on gender, and I know that I'm almost out of time, but a final point on gender. One of the key problems here, I think, is the lack of understanding of gender-sensitive approaches to victims, both women and children and girls who are deeply affected by trafficking for sexual exploitation, but also men and boys who are also impacted. And the UN has increasingly recognized the exploitation of men and boys, I think in recent resolutions, but we need better training and support for the practitioners on the ground to understand specific needs based on gender and how to respond to them. So those are just a few ideas about how we might try to close the impunity gap. Thanks very much.
Val, thank you very much. It was quite almost made me pause and stop to see how large the impunity gap is. And I'm sure we're talking about it not only during periods of armed conflict where it's even heightened, but even during what we could call normal periods of times. And it's not as if we don't recognize criminal conduct that's occurring before us, and not as if we don't have an absolutely beautiful protocol. I think you're right that there's something about political will. And I think there's something about having really a gender competent approach. But I'd like to turn now to some questions that have come in from our audience. So let me see. This very privileged group will now be able to respond to our great audience. The first question that comes in is to Amina. Amina, before being an activist in this area, you served as a member of the Iraqi parliament. In your opinion, what could parliamentarians do to address this sexual violence crimes associated with trafficking, slavery, or the slave trade? Could you talk to your former parliamentarians and see what initiatives or what policies or laws could they put forward? Amina, your response, please.
This is a good question, because the main job of parliament is to legislate. So the parliament can do many things to prevent sexual violence and to respond to what happened in Iraq. So I'm here to talking about Iraq. Regarding sexual violence, I think it is important to have laws that first prevent the child marriage, because we have trouble things with child marriage with the girls, which I see as a part of sexual violence and rape. Then it is important to follow up on these laws and make sure that they are actually applied, and the parliament should not neglect this issue. Another thing that the Iraqi parliament could do was to vote to approve the recognition that what happened to Yazidis in 3rd of August 2014 was a genocide, and unfortunately they didn't attempt it was a genocide, although the parliaments of some other countries discussed and agreed that the Yazidis were targeted because of having a different religion. And even when ISIS captured all of these people and killed all of the men and some women, they said because you are infidels. They called Yazidi infidels because of them different religion. So as for Iraq, unfortunately, although there was a speech and there has been discussion about what happened to the Yazidis, a law recognizing the Yazidi genocide might never be adopted because the current parliament only has some months in this term, and if the law is not adopted, it will have to be resubmitted. There is also a bill in parliament to compensate the survivors supporting and morally, which if approved would allow the survivors of the various components to benefit from it. The reason for this delay regarding to the recognition of the Yazidi genocide and bringing justice to victims is the lack of concern by members and parties, the lack of agreement between the different parties, and the many internal problems make it difficult to take such topics into consideration and make them priority. Having the conflict between different parties and the instability in the whole country creates obstacles in legislating. On the other hand, the Parliament's role in stopping or reducing sexual violence is very difficult. And because some areas where they have conflicts or areas that suffer because of war and poverty, these factors will cause instability, and terrorist groups are preventing the imposing the law. As for the judiciary, the parliament doesn't have the right to intervene, but the parliament could ask that the existing laws are used, like the law in trafficking. And Parliament can also form investigation committees and reveal the identity of those who were involved in the crimes and the killers. But unfortunately, in Iraq, we suffer from many problems, and this is what the situation has led into terms of murder, displacement, kidnapping, and rape. In general, parliaments can legislate laws that criminalize anyone who supported or cooperated with terrorists and anyone who was hiding information from the judiciary. We have experienced what happened to us as Yazidis and our victims. Governmental institutions, including parliament and related parties, didn't take serious actions regarding kidnapping our girls, including sexual and psychological violence. And that is very sad that we're facing actually.
Amina, thank you very much, because it allows us to understand that political will is not an abstract concept, that there are political actors behind a lack of political will, and that it certainly impinges upon impunity, just the recognition of genocide or the setting up of committees or the legislating of laws to protect or to redress and compensation. Thank you very much. Another question we've come in, and this one is for Val. Val, you talked about how the survivor, victim of trafficking, could also seem to be an accomplice or perpetrator of crimes such as terrorism due to support or affiliation and membership. And the person would like to know, could you please tell us how OSCE, your organization, works with prosecutors and authorities to assess these individual situations or to address these situations?
Yeah, thanks for the question. I mean, this is a very interesting situation where we've seen several instances of this throughout the OSCE region, where folks who were recruited deceptively, coercively, forcefully by terrorist groups were brought in, were subjected to sexual slavery and so forth, and then were eventually prosecuted for contributing, being a member of, or contributing support to terrorist groups. And we collected dozens of cases from across the region and analyzed them for trafficking elements, and saw that time and time again we were seeing this act, this means, and the purpose there. And so from our perspective, there was a scenario under which they could be both a victim of trafficking and prosecuted for contributing material support or being a member of a terrorist organization. That's a major problem. That's a serious conflict in laws where somebody could be both a perpetrator and a victim. So what we've done is collect those cases, we've analyzed them, and in the next month or so, we will be publishing a comprehensive paper going through and discussing some of these issues of conflict of law. I have two suggestions for countries that are dealing with this possibility. One is bring your terrorist investigatory and prosecution authorities and your trafficking authorities together and discuss, because it's really crucial to figure out where there's conflicts in laws, so that victims are not prosecuted. That's completely unacceptable. That needs to happen. The second thing is flip it for your benefit. And what I mean is terrorist organizations should not only be prosecuted for terrorism, they should also be prosecuted if they're trafficking people. And currently they are not being prosecuted for such. So when somebody recruits a teenage girl from a country into another country and she's then subject to sexual slavery, they should be prosecuted not only for whatever else they've done, but also for the trafficking piece. This is really crucial. And so I think we're seeing cases where the wrong people are being prosecuted, and we're missing opportunities to ensure justice and hold these organizations accountable. And that's a missed opportunity.
It seems to me that there's at times that the survivor of trafficking is basically your insider witness for the terrorism.
Absolutely. This person could be hugely helpful to not only a terrorism prosecution, but also their own victimization and exploitation as a victim of trafficking. I think that's absolutely right.
Thank you. Okay, the next question has come in and they would like Amy and Stephanie to answer. Have there been any prosecutions of ISIS fighters for trafficking or is the crime of the slave trade to your knowledge since you've been building cases?
Thanks, Patty, for the question. To my understanding, there have not yet been any ISIS prosecutions for trafficking persons. We're aware of the first charge of such kind in Germany, and we're following closely that case, which will be very interesting. I think, though, when we think about the Iraqi law, they have had trafficking in persons legislation since 2012. And this was also adopted in KRG, in the Kurdistan Regional Government, in 2018. And it's actually a very solid framework. So it meets, it's very comprehensive and meets it's in compliance with the UN Trafficking Protocol. Of course, like in every country, there are a few areas for legal reform, which we are looking to support when there's interest. We would be very interested in supporting a principle of non-punishment, which is something that Val was just referring to. We would love to have that kind of institutionalized. And we would also like to work on the issue of children and consent to have that language a bit stronger. But overall, you have a very fantastic, comprehensive national legislation in Iraq. And I think, we have to think about how to bridge this huge gap between, those who are looking at international justice mechanisms that are going to be targeting, 5, 10 suspects and the vast majority of the body of this crime. And I think this is really an opportunity for Iraq, for example, to really, be a role model for other countries in looking at this. So we would be very keen to support that.
Yeah, I think I agree with MA. I have not seen any prosecutions for the crime of the slave trade under Iraqi law or in any other jurisdictions, which is unfortunate, I think, especially given that there are many suspects in custody and going through terrorism proceedings in Iraq. And as one of our audience members has mentioned in the Q&A, there is no codification of war crimes, crimes against humanity, or genocide in Iraqi law. But there are other legal provisions that might might characterize some of the conduct within them, and that could be looked at. And MA is correct, there are some cases in Germany. One of them is taking place in Dusseldorf. That's the case of Sarah O, which is ongoing, but I believe the proceedings are closed to the public because she was a minor at the time of her crime. She's charged with trafficking, membership in a terrorist organization, war crimes, and deprivation of liberty. And her conduct is alleged to be holding 3 Yazidi slaves in her home. There's another case, which is against an Iraqi national, a man, Taha Al-Jay, and that case is taking place in Frankfurt am Main. And he is charged with genocide, crimes against humanity, war crimes, membership in IS, and trafficking in persons. And his alleged conduct is enslaving a 5-year-old Yazidi girl and allowing her to die of thirst. And that trial is also ongoing. I think what's really interesting about the German cases that have included trafficking charges is that it's quite significant that we see them charging trafficking alongside offences under international criminal and humanitarian law. It's such an interesting approach, and one that might be worthy of consideration in other jurisdictions as well. And it does remind me of Aimé's wonderful article where she looks at the different elements of these offences, but we really can see that even though the elements to be proven are distinct from one another, the same evidence can really satisfy a lot of what needs to be proven as trafficking or as an ICHL crime. So it could be very interesting for legal practitioners from different jurisdictions from within the region and in these European jurisdictions that are doing these complicated prosecutions of their foreign terrorist fighters who traveled to Syria, to see if they can learn from each other and have discussions about cumulative charging.
Thank you, Stephanie. As a matter of fact, you lead into another question that has come up. This is for Jocelyn and for Val, as it says that we've been talking specifically about crimes and we have to presuppose individual criminal liability for slave trading and human trafficking. So what would either of you suggest is the best way of charging? Stephanie's already brought up the issue of cumulative charging. Would you agree that cumulative charging, but across different legal regimes, transnational law, international criminal law, should be applied? And what about the issue of state responsibility for trafficking or for slave trading?
Go ahead, Jocelyn.
Well, I think I'm better equipped probably for the second half because you're the prosecutor and I'm the human rights lawyer. But I can opine and see how you think about it, if you agree or not. But I think, and we're also talking about improving, political will. And I think we need to be thinking about, in addition to individual criminal accountability as practitioners, to also remember state accountability, state responsibility for these crimes and the failure of due diligence to adequately investigate, prosecute, and punish these crimes as per their legal obligations under human rights treaties. And as I mentioned, slavery and slave trade are enumerated in several human rights treaties as well. The UDHR, the ICCPR, among others, includes both slavery and slave trade. And the CEDAW, importantly, includes trafficking in women and girls. And then the Palermo Protocol defines very specifically trafficking. So I think it's really important that we think about the state accountability for the inability of the prosecution and holding individuals to account. The CEDAW committee, through its General Recommendation 38, which was just released this past November, reinforces these distinctions and of these different distinct crimes, trafficking, slavery, and slave trade, which is incredibly important under these regimes, that we keep each of these crimes and each of these human rights violations distinct. We understand the very important differences, but that we are looking at all of them and making sure that we are trying to, from a victim, survivor's perspective, ensure full accountability. So it will depend on jurisdiction, it will depend on statute of limitations. Like I said, the slave trade and slavery, they are super norms. So these, these particular crimes could be pursued, I think, very widely, and we should be definitely including them as we look to how do we hold perpetrators to account.
Yeah, I completely agree. I think that there are going to be, first of all, a lot of facts that are going to caveats. I could caveat for an hour before getting to the answer. The legal system, fact considerations, and so forth. But in general, I think that the point is that we should be using all the tools in the toolbox. And I always like this example, this kind of legendary story in the U.S. about Al Capone, who was the most prolific organized criminal in American history, and they could never get him on organized crime. They just couldn't get the evidence. So they prosecuted him on tax evasion, which sounds ridiculous, but it was the one way they could get him, and they did. And he went to prison. And so you look at that and you think about, well, if you can't get this group on slavery or terrorists, why not go after them for trafficking? Because you might be able to get it there where you couldn't get it on something else. And so I think that we need to be creative and flexible in thinking about the charges. And if they committed all the crimes, then certainly we should load them up, because I mean, we're talking about some of the worst crimes that people do to each other here. And I don't see any reason right now that they deserve a break for those. There's not a sale on crime right now, especially when it comes to sexual violence. So I think there's some good options here, and we probably want to think about proportionality and so forth. But really, as Jocelyn said, as far as state responsibility, that's not an area that we have looked at a lot. However, I will say that increasingly we are seeing countries holding their officials somewhat accountable for participating in some of these types of crimes, particularly in the area of trafficking. And I think one thing that can be useful is starting small and building big. If you try to go after a state in a really comprehensive way, it's a very, very onerous, very expensive, very difficult, resource intensive. But you can start by holding, for example, police accountable for crimes that they might commit. And that's a really good place to start to demonstrate the rule of law that I would urge countries to think about first.
Well, right now I'm feeling pretty optimistic. We have a lot of tools in that box that we could be pulling out to build a better house that disallows impunity. Look, the last question is two-part. It's to Aimee. And it says, what do we need to do better? And where do we need to invest in to improve our response to human trafficking or slavery and conflict, especially as it relates to sexual exploitation? And then a second part is that because you're at the United Nations Office of Drug and Crime, what about the crime of smuggling? Is it possible that some of the factual patterns in smuggling are actually crimes that relate to the slave trade?
Thanks, Patty. As to the first question, what do we need to do better? I think it's really important to recognize that this is long-term change, and it takes time. It really takes time. It takes resources and capacity to build up national responses to this crime. And I mean, I can think of a number of areas where we're seeing good results. Policy and strategies are very important at the national level. So we're very active working on national action plans and making sure that there are no gaps in terms of victim protection, making sure that there's a national referral mechanism, etc. Legislative assistance is incredibly important. So most countries have the framework, and mostly the legislation is comprehensive, but there are small changes that continually need to be made. But I think what's really needed is capacity building, and we are learning a lot in terms of capacity building, how to do this more effectively, how to result in behavioral change. And we believe that actually mentorship is the way to go, rather than the traditional workshop setting that may also be relevant. But mentorship is really key, and within the spirit of a community of practice and a partnership. And again, we are trying to promote women as much as possible, women police officers, women prosecutors, women judges. It's absolutely key that women be involved in this response. And currently in the region where I'm working, in most parts of the world, women are gravely underrepresented in the response. In terms of learning, we also see a lot of value and benefit in peer learning. So we do a lot of exchanges, for example, judges from one country with another country, that often is more effective than having internationals, staff, going through that. Immersive learning, such as mock trials or simulation-based learning, is very successful. It's very much appreciated by the participants, and it's a much more realistic way, and you're forced to kind of put into practice the learning. Mock trials is another example of that kind of immersive learning. And then international cooperation is absolutely needed, and that's very difficult. The relationships between different governments are very complex. So what we see is often more successful sometimes is working on a bilateral specific route between two different countries and try to see where there really is some political will to address the issue. And then we think about joint investigations. They take a lot of resources, simple things like translation or having interpreters available, that costs money and is often too difficult for governments without necessary support. So that's really key. And then I think what's really lacking and what's really needed is greater attention to victim protection and assistance. And there's so many needs in this area. Victims by and large do not have redress to all of the remedies which are in the protocol, which are in national law. Very few victims are able to access compensation, which is a great shame. But the law, and in most cases the policy, supports the fact that victims should have time to recover, to rehabilitate, and they should have restitution for their crimes. And overall, I do agree with Val that the issue of political will is incredibly important, and we have to be, acknowledge also where we are working, and in the countries where we're working, for example, in Afghanistan and Iraq, human trafficking is not at the top of the agenda. There are many, many other priorities, political insecurity or actual security in Afghanistan. We saw recently the assassination of 2 female judges. So there are many, many other competing items on the agenda. We're not saying that human trafficking has to be the top of the agenda, but we have to work with our partners and allow them to see the importance of this work and to support them as they go forward. And we're really pleased that they are prioritizing trafficking in persons and they do want to work on these issues. As to the question about smuggling of migrants, that's very interesting. I haven't actually considered that before. Smuggling of migrants, of course, is a separate legal framework, and we often emphasize the differences between the two. But in conflict areas, we do often see a conflation between trafficking and smuggling. So a person may leave one country with the intention of taking a job offer in another country. It turns out to actually be a situation of human trafficking, and along the way, it may also be smuggled migrants. In terms of the links with the slave trade, I think it's possible, definitely. The difference with the migrant smuggling legislation is we often refer to it as a crime against the state. The focus is on the national sovereignty, whereas the focus of human trafficking is really the person, the victim at the center of it. But indeed, it could be part of the fact pattern. I think so. Thank you.
Thank you very much. Oops. Val, if you could tell us, respond to this question about what is the essence or what is needed in terms of political will.
Yeah, there was a great question posed by the audience on how do you build political will? And that's something that a lot of us have spent some time trying to figure out. But what I can say is one way is by emphasizing to authorities their obligations under international and domestic law. That's the aggressive way. And it can be useful to have that backdrop. I'll be honest though, I think that the aggressive way is not always the effective way. I think the second way is to really get people to believe they need to do something. They have to feel it. And the way you do that is with awareness. There's two ingredients I think are useful here. One is survivor stories. It's very difficult to not take action when you listen to somebody's story. It's really, really hard. And the second is data that supports that story to show the scale and scope of the problem. If you put those two things together and you build awareness, I think you have the foundation for getting political will. Thanks.
Thank you very much. I've been given the task to summarize. I mean, how does one summarize after such brilliant presentations, orations, and information? But what I would like to say is that prior to today, I don't think there's ever been a discussion where practitioners, members of civil society have come together to look at trafficking, to look at slave trading, and to look at slavery or sexual slavery caught within the middle of this. And what we've come out of is learning that if we're going to get back to human dignity, we have to get to justice. We have to eliminate impunity. But the legal regimes, whether they be under international humanitarian law, international criminal law, under the customary basis, or under transnational law, exists, give us, as we've said before, tools that we can use concurrently, cumulatively, that are complementary to each other. It appears to me that trafficking in human beings, the slave trade, might be conduct that dates for thousands of years, but it's conduct that's occurring today and in this year. And I think that we as members of the international community, we as potential and past survivors, we have an obligation to make sure that all of those tools remain primed, finely tuned, but more all utilized whenever possible. Political will, this is part of your task also. Thank you very much. And now I want to turn this back over to Chloe.
Thank you, Patricia, and thank you so much to all of the panelists for this deep dive into the complex issue of conflict-related sexual violence associated with slavery and trafficking. I'd also like to extend a great thank you to the Institute for the Study of Human Rights of Columbia University, which has hosted us today. Today's session will become available online on YouTube, as well as on the UN Team of Experts page quite shortly, as of all of the sessions for the series. And we will be continuing the series of webinar next month. Our next session will address the issue of reparations for conflict-related sexual violence, also quite a thorny issue, which is under experienced. So please stay tuned for more information about that event. Thank you again, Patricia, and all the panelists, and to the audience for attending this dialogue with us. And we hope to see you soon for the future session. Goodbye.